Chapter 7. Collectability. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. Collectability assessment answers this question: will I get paid if I win my case? You have won after years of battling in the court system, a few days in arbitration, or an hour in small claims. You sit in your easy chair happy it's finally over and study the piece of paper you received. It's called a judgment. It says you are the prevailing party and quantifies the amount to which you are entitled. This sounds like really good news. Now you wonder when you will get it? This person we refer to as Easy Chair Harry is in for a life lesson. The answer to his question is you will most likely not get it until you chase down the assets of your adversary who has now become your debtor and you became his creditor. All you really have now is a piece of paper saying you won. If you don't have a debtor willing to pay up voluntarily, you have another nerve-wracking, time-consuming job ahead. With this chapter in hand, long before he files his action, Smart Harry becomes a private detective of sorts. If his adversary isn't a juicy one, he will seriously consider whether to proceed with his legal journey. Assessing collectability. Easy Chair Harry plowed headfirst into litigation when emotions were high without thought to whether he would be able to collect the fruits of his labor. Smart Harry's first step before taking legal action should be to assess his adversary's financial status. Does his adversary have assets that can be levied upon? All the work it takes to get a judgment will be for nothing if he can't collect on it. This step involves a little advanced detective work that is well worth Smart Harry's time. Online detective work. Where do you start? When you complete the chapter on naming and locating defendants, you are on your way to finding this information. This type of investigation used to require a lot of footwork, but now that everything is on the internet, you just need to know which site to check. You can also purchase asset check reports, background reports, or other similar reports online. Answering these questions will give you a good head start. 1. Do they own real estate? Check the recorder's office or assessor or tax collector's website under the name of your adversary in the county where your adversary lives and in surrounding vacation spots to locate a home or vacation property. 2. Do they have a sole proprietorship? In your adversary's locale. A. Check the county clerk records online for fictitious business name statements. B. If they operate within city limits, check with the city clerk for their business license. 3. Is your adversary a corporation, limited liability company, general partnership, or limited partnership? See our chapter, Naming and Finding Defendants. Check the Secretary of State database where documents filed provide valuable information about ownership and assets. 4. Do they hold a professional license, and does your claim against them involve those specific professional services? Go to the state licensing website for their trade to find out. 5. Do they hold a driver's license and your claim against them relates to their driving? Go to your local state DMV to find out. 6. Perform an online search of the county recorder or clerk's office. A. For unpaid judgments outstanding against them. If there are other unpaid judgments, you might just decide to forego your action against them as you probably will not be paid either. B. Have they filed for bankruptcy recently? If so, they will not be able to avoid your judgment by again filing for bankruptcy protection soon. 7. Perform an online search of the county recorder office for divorce records which can provide all kinds of valuable information about assets. Assessing collectability with Lawsuit Analyzer. Based on your detective work, the Lawsuit Analyzer app performs a collectability assessment by asking you to choose your adversary's financial status from the following list, ranked from juiciest defendant to a dry one. Is a corporation. Will be represented by an insurance company. Is an operating business other than a corporation. Is a person who owns real property. Is a person who has assets and is salaried. Is a person who has assets and works as a sole proprietor. Is a person with assets and none of the above apply. If none of the above or below apply. Has other judgments against them. Has no assets or means of support. Has bankruptcy proceedings pending which will include your judgment. Phase 4 of Lawsuit Analyzer performs a collectability assessment based on your research of your foe's financial standing by asking you to choose from the first scenario that applies in the above list. That ranking is then utilized in Phase 5 of Lawsuit Analyzer to provide a case feasibility analysis. In the chart below, Smart Harry is smiling since his adversary is very juicy as the owner of a home. Focus on collectability more. While Lawsuit Analyzer factors collectability into your overall case analysis, don't stop there when you are making the pivotal decision whether to file your action against your adversary based on collectability status. Carefully analyze the information you have obtained and make your own independent determination of whether it makes good sense to go through what it will take to get a judgment against your adversary. If you decide to proceed based on your adversary's financial status, make sure you also understand the specific collection procedures below and the steps that must be undertaken by you or a representative you will hire. Assets to collect upon. Review your investigation results and match them up with the following ways to scoop up your adversary's assets. If they own a business, your chances of collection improve. Make sure you name both the business and the individual as defendants in your case if the business was involved in the subject of your dispute. You should be able to scoop up the business assets. If they have an ownership interest in a corporation, limited liability company, general partnership, or limited partnership, you may be able to levy their interest. If they work for themselves or someone else, you may be able to garnish their wages. If they own real estate, subject to meeting certain requirements, your judgment can likely be recorded as a lien against their real estate. When your debtor sells or refinances the property, your judgment will likely have to be paid off. If you discover bank accounts, see below about how to do this. The funds can often be scooped up to satisfy a judgment. If they own boats, planes, or vehicles, these types of registered personal property assets may sometimes be sold. There are limitations, but these are generally the rules. If they hold a professional license and your claim against them involves those professional services, you may be able to have their license suspended by the licensing board until your judgment is paid off. If they have a driver's license and your claim against them relates to their driving, your local DMV may be able to have their license suspended until your judgment is paid off. Following your analysis of the above, you should be well equipped to decide whether to file an action against your adversary. If you decide to proceed, once you have your judgment, pan down to information about more specific judgment collection procedures available. Begin collection procedures. Once the judgment is entered into the court's records, everything changes. Plaintiff becomes the judgment creditor and the defendant becomes the judgment debtor. In most states, we're highlighting California here, but most states follow suit. The debtor has 30 days after the judgment is entered before they must pay you. During this time, the debtor can voluntarily pay the judgment. Ask the court to order an installment payment plan. In most states, if requested by the debtor, the judge can order payment of the judgment in installments over time. See California's form to make this request. File an appeal. Fill out and send you a judgment debtor's statement of assets. The judgment debtor's statement of assets is chock full of information. The court is doing a great job of guiding you through the collection of your judgment. There is a multitude of ways to collect on a judgment and easy-to-complete forms to help you seize the debtor's assets. If the debtor completes their assets list accurately, you just grab the collection form that fits the asset of your choice, and away you go. Smart Cookie Tip. Check out CA Small Claims Court Collection Instructions to guide you through this process and provide you with all the forms. A similar process applies to judgments in other than small claims court. Most often the debtor doesn't complete the statement of assets or is less than transparent, so you move on to the next step to enforce your judgment. In lay terms, this means go digging for assets. Although most states have methods set up in specific forms to help you do this, it doesn't happen automatically. You need to be aware of the steps and take them. In California, enforcing your judgment when the debtor's statement of assets is incomplete is to initiate a formal proceeding called a judgment debtor examination, where you will obtain asset information directly from your debtor's lips. Other states have similar proceedings. You can ask about where the debtor works, how much he or she earns, bank accounts, stocks, other income sources, property and belongings, and anything else that can be used or sold to pay the judgment. It's humiliating and quite invasive, but it is what happens when one becomes a debtor. Check out California's list of suggested questions to ask your debtor. You can also subpoena the debtor's paycheck stubs, bank records, deeds for any property he or she owns, and similar documents that prove the existence and value of the debtor's property. Go to your state's self-help website or conduct an internet search, collect on court judgment in, then name your state, to locate the many available forms, which typically also describe the rigmarole associated with each procedure. Smart cookie tip. In most states, if the debtor owns real estate, there is a simple method of recording the judgment as a lien against their property. Keep in mind, also, that you can hire a collection company to handle this for you. They usually get paid based on a percentage of assets recovered. You can also sell your judgment to a company that will pay you here and now. They don't give much on the dollar, but this is a resource to consider. A judgment is a good investment. Your small claims court judgment bears the post-judgment interest rate in your state until paid, in some states as high as 10% per year. Determine the post-judgment interest rate in the state you file your case in by accessing the state's website information. High interest is a big inducement for the losing party to pay your judgment as soon as possible. If you have a juicy debtor, you may want to wait as long as possible to be paid on your new high-interest investment. If your debtor has no assets or apparent source of income, there will be little chance of collecting on your judgment. However, in most states, your judgment is good for many years and can continually be renewed, if renewal is completed before its term expires. Make sure you find out how long a judgment lasts in your state and renew it a few months before it expires. Smart cookie tip. If your debtor is not juicy, assess whether he is likely to be more solvent in the future via inheritance, graduates from college and will get a good-paying job, or can be expected to have some other economic turnaround. If so, revise your plan accordingly while also keeping in mind that you must file suit before the statute of limitations expires. More about this in our chapter Where and When to File Your Lawsuit.